Stop right there before you make any assumptions about your U.S. citizenship being safe and permanent, because what I'm about to reveal could genuinely be the difference between keeping your American citizenship and losing it forever. These brand new denaturalization rules aren't some distant future concern that might affect a handful of people. They're being rolled out right now in 2026. And the truly terrifying part is that millions of naturalized American citizens have absolutely no idea that their citizenship could potentially be at risk. I'm not exaggerating when I tell you that one mistake from your past, one inconsistency in your immigration history, or even one misunderstood question during your naturalization process could come back to haunt you years or even decades later. This isn't fear-mongering. This is the reality of what's happening in American immigration law right now, and you need to understand exactly what's changing before it's too late. Stay with me because the next few minutes could literally protect your citizenship, your family's future, and everything you've worked so hard to build in the United States. Welcome back to U.S. Immigration Insight, and I cannot stress enough how critical it is that you're watching this video today. We need to have an absolutely vital conversation about changes that are fundamentally reshaping the landscape of U.S. citizenship and naturalization law. The year 2026 is witnessing some of the most comprehensive, far-reaching, and dramatic alterations to denaturalization procedures that we've seen in modern American history. These aren't small administrative tweaks or minor policy adjustments that only affect a few specific cases. We're talking about substantial game-changing modifications that could impact how the government reviews naturalization cases. What triggers an investigation into someone's citizenship, how far back they can look into your immigration history, and what grounds they can use to potentially strip someone of their American citizenship. Here's what genuinely concerns me. What keeps me up at night thinking about the millions of honest, law-abiding, naturalized Americans who could be blindsided by these changes. The government hasn't exactly been broadcasting these new denaturalization rules from the rooftops with clear, accessible information that everyday people can understand. There's been no massive nationwide public awareness campaign reaching immigrant communities across the country. There haven't been informational materials sent to naturalized citizens explaining what's changing and why it matters to their daily lives. There haven't been town halls or community meetings in multiple languages, making sure people understand their rights and responsibilities under these new rules. There haven't been advertisements on television, radio, or social media in different languages, warning people about what's coming. What this effectively means is that millions of hardworking, naturalized Americans, decent people just like you and me who followed the rules, studied for the citizenship test, took the oath of allegiance, and believed they had earned permanent, irrevocable American citizenship, could wake up one morning completely blindsided by an investigation they never saw coming. They could suddenly discover that something from their immigration past, something they disclosed or didn't disclose years ago, something they thought was resolved and behind them, is now being scrutinized under these new, stricter standards with potentially devastating consequences. That's precisely why U.S. Immigration Insight exists. Why I dedicate myself to creating this content for you week after week, spending countless hours researching immigration law changes, policy updates, and regulatory shifts. I'm here to cut through all the government bureaucracy and confusing legal jargon, to bring you the information that genuinely matters to your life and your family's future, to keep you protected, informed, empowered, and confident as you navigate all the complex changes in American immigration law. My mission, my absolute commitment to each and every one of you watching, is to make certain that you're never caught off guard, never taken by surprise, never left vulnerable to laws and regulations you didn't even know existed. I want you to have the knowledge and tools you need to protect yourself and your loved ones in this increasingly complicated immigration landscape. Today's video might genuinely be one of the most important, most valuable, most potentially life-changing pieces of content I've ever created for this channel. And I'm not saying that for dramatic effect or to get views. These denaturalization rule changes don't just affect certain categories of naturalized citizens or people from specific countries. they potentially affect every single person who went through the naturalization process to become an American citizen. Regardless of when you naturalized, where you came from originally, or how long you've been living as an American citizen, whether you became a citizen last year or 20 years ago, whether you came to America as a refugee fleeing persecution, through family sponsorship by a loved one, through employment because of your special skills, through the diversity visa lottery, or through any other pathway that exists in our immigration system, whether you're 25 years old or 75 years old, whether you have children who are U.S. citizens or you're the first in your family to achieve citizenship, these changes could potentially impact you in ways you never imagined. There are no automatic exemptions, no protected categories, no special safe harbors, no guarantees that your citizenship is absolutely safe from review just because you've been a citizen for a long time or because you've never had any problems before. So, please do me an enormous favor right now. Hit that subscribe button below this video and turn on those notification bells, because this information could genuinely protect your citizenship, your family's security, and everything you've worked so incredibly hard to achieve in the United States over the years. It could help you understand your rights, know what to watch out for, recognize warning signs, and take steps to protect yourself before any problems arise. Let's dive straight into these absolutely critical changes, and I'm going to explain each one in crystal clear, straightforward language so you understand exactly what's happening, exactly what could trigger a denaturalization investigation, and exactly what you need to do to protect yourself and your family from this growing threat. Let's start by making sure everyone understands what denaturalization actually means, because there's a lot of confusion and misinformation out there about this topic, and I want to make sure we're all on the same page. Denaturalization is the legal process by which the United States government can revoke or take away someone's citizenship after they've already been naturalized and become a full citizen. This is completely different from deportation of green card holders or removal of people without legal status. We're talking about people who went through the entire naturalization process, studied for and passed the citizenship test, attended the naturalization ceremony, took the oath of allegiance with their hand over their heart, received their certificate of naturalization, and became full American citizens with all the rights and responsibilities that come with citizenship, including the right to vote, the right to petition for family members, and the right to live and work permanently in the United States without any restrictions. For most of American history, denaturalization was extremely rare, reserved only for the most serious cases involving major fraud, like Nazi war criminals who lied about their past to enter the country after World War II, or people who committed serious crimes and completely fabricated their identity and background to hide their criminal history. The general principle that guided American immigration law for generations was that once you became a citizen, that citizenship was permanent and irrevocable, except in the most extreme circumstances involving deliberate serious fraud that went to the heart of someone's eligibility. But over the past several years, and especially now in 2026, we've seen a dramatic shift in how aggressively the government pursues denaturalization cases and how broadly they interpret what constitutes grounds for stripping someone of their citizenship. The Department of Justice has created specialized task forces specifically dedicated to identifying naturalized citizens who may have obtained their citizenship through fraud or misrepresentation, with teams of attorneys and investigators working full-time on nothing but denaturalization cases. The Department of Homeland Security has been given additional resources, increased funding, and expanded authority to investigate citizenship cases going back many years, sometimes decades, into someone's immigration history. Immigration and Customs Enforcement, known as ICE, has been working with other agencies to cross-reference databases, share information, and identify discrepancies in people's immigration histories that might justify reopening their naturalization cases and questioning whether they should have been granted citizenship in the first place. Let me be very clear about what the legal grounds for denaturalization are under current federal law. because this is crucial for you to understand, and it will help you assess your own situation. Under current law, which is being more aggressively enforced under these 2026 changes, the government can pursue denaturalization in several specific situations that are outlined in the Immigration and Nationality Act. First, if you obtained your citizenship through deliberate fraud or willful misrepresentation of material facts. This means you intentionally lied about something important during your naturalization application or interview, and that lie was significant enough that it could have affected the decision to grant you citizenship. Second, if you illegally obtained your citizenship, meaning you didn't actually meet the eligibility requirements but somehow got approved anyway, perhaps because of a mistake by the immigration officer or because you concealed disqualifying information. Third, if you joined a subversive group or organization within 5 years of naturalization, which could indicate you took the oath of allegiance in bad faith and never really intended to support and defend the Constitution of the United States. Fourth, if you received a dishonorable discharge from the U.S. military, if you naturalized through military service, which is a special pathway to citizenship for those who serve in the armed forces. And fifth, this is the one that's becoming increasingly important under the new 2026 rules and causing the most concern in immigrant communities across the country. If there were any concealments or misrepresentations of material facts during your immigration process before naturalization. Not just during the naturalization process itself, but going all the way back to your very first contact with the U.S. immigration system. This last category is what's causing the most concern and anxiety in immigrant communities right now because it dramatically expands the time frame and scope of what the government can scrutinize when they're deciding whether to pursue denaturalization. They're not just looking at what you said on your N-400 naturalization application or during your naturalization interview with the USCIS officer. They're going all the way back to your very first interaction with U.S. immigration. Whether that was a tourist visa application at a U.S. embassy or consulate abroad 20 years ago, an asylum application filed at the border or with an asylum office, a green card application filed through family sponsorship or employment, an application for a work permit or student visa, or any other immigration benefit you ever requested from the U.S. government at any point in your life. They're cross-referencing all of these applications and interviews against each other using sophisticated computer databases and data matching technology, looking for any inconsistencies, any discrepancies, any information that changed from one application to another, any facts that you mentioned in one context but not in another, any dates or details that don't match up perfectly across all your applications over the years. Now, let me explain in detail what kinds of issues are triggering denaturalization investigations under these new 2026 rules, because understanding this could help you assess your own situation and determine if you might be at risk and need to take protective steps. One of the biggest categories that's leading to denaturalization cases involves criminal history and arrests. And this is where many people get caught completely off guard. If you were ever arrested or charged with a crime at any point in your life, even if the charges were later dropped or dismissed by a prosecutor or judge, even if you were found not guilty at trial, even if you completed a diversion program or deferred prosecution agreement that resulted in the charges being erased from your record, you were required to disclose that arrest on your naturalization application. The application specifically asks about any arrests, citations, detentions, charges, or offenses, regardless of the outcome or final disposition of the case. Many people misunderstood this question and only reported actual convictions, thinking that if they weren't convicted or if the case was dismissed, they didn't need to mention it because it wasn't on their record anymore. But that's not what the question asks. It asks about arrests, period. Under the new enforcement priorities, failure to disclose arrests, even if they didn't result in convictions, is being treated as a material misrepresentation that could support denaturalization, even if the arrest happened 20 years ago and had nothing to do with whether you were eligible for citizenship. Another major category involves prior immigration violations or periods of unlawful presence in the United States. If you ever overstayed a visa, even by a single day, if you ever worked without authorization, even for a short period to support your family, if you ever misrepresented anything on a visa application or at a port of entry when entering the country, these are all facts that should have been disclosed during your naturalization process if they were relevant to establishing your eligibility for citizenship. Some people obtained green cards through marriage to U.S. citizens, but had previously been in the United States without legal status or had previously overstayed a different visa before they met their spouse. If they didn't fully disclose their complete immigration history, including all periods of unlawful presence and how they entered the country each time, this could now be grounds for denaturalization, even if they've been citizens for many years. A third category that's getting a lot of attention involves misrepresentation about identity, family relationships, or marital status at any point in the immigration process. This includes things like using a false name or date of birth at any point in your immigration journey, claiming to be single when you were actually married in your home country, or claiming to be married when you were actually divorced, failing to disclose children from previous relationships on family-based immigration applications, lying about educational credentials or work experience to qualify for employment-based visas, or using someone else's documents or identity to enter the United States or obtain immigration benefits. Even if these misrepresentations seemed minor or unimportant at the time, if they were material to obtaining an immigration benefit, meaning they could have affected the decision, they could potentially support a denaturalization case under the current aggressive enforcement climate. A fourth category that's getting increased scrutiny from immigration authorities involves fraud in obtaining the underlying green card that made you eligible for naturalization in the first place. Remember, to naturalize, you generally need to have been a lawful permanent resident for at least 5 years or 3 years if you obtained your green card through marriage to a U.S. citizen. If the government determines that your green card itself was obtained through fraud or misrepresentation, then your naturalization was also illegally procured because you weren't actually a lawful permanent resident at the time you applied for citizenship. This is leading to cases where people who have been U.S. citizens for 10, 15, or even 20 years are having their citizenship challenged because of alleged problems with how they got their green card decades ago, issues that were never raised or investigated when they applied for naturalization. Now, let me walk you through what actually happens if you become the subject of a denaturalization investigation, because understanding the process can help reduce some of the fear and anxiety around this topic and help you know what to expect. It typically starts with a notice from the Department of Homeland Security or the Department of Justice informing you that your naturalization is being reviewed and they're looking into how you obtained your citizenship. You might be asked to appear for an interview to answer questions about your immigration history and naturalization application, and they'll want to go through your entire immigration file with you. You might be asked to provide additional documentation or evidence related to your case, such as old passports, visas, entry stamps, employment records, tax returns, or other documents going back many years. The government will conduct its own independent investigation, reviewing all of your immigration files that they have in their possession, potentially interviewing witnesses who know about your immigration history, checking multiple databases, including criminal databases and travel records, and gathering evidence to support their case. If the government believes there are sufficient grounds for denaturalization based on their investigation, the Department of Justice will file a civil lawsuit against you in federal district court seeking to revoke your citizenship and cancel your certificate of naturalization. This is a serious legal proceeding in federal court, and you absolutely need to have an experienced immigration attorney representing you who specializes in denaturalization defense. You cannot handle this on your own without a lawyer. The stakes are too high and the law is too complex. The burden of proof in a denaturalization case is on the government, and they must prove their case by clear, unequivocal, and convincing evidence, which is a higher standard than the normal preponderance of evidence standard used in most civil cases. However, if they meet that burden of proof to the judge's satisfaction, the judge can order that your certificate of naturalization be revoked and canceled, stripping you of your U.S. citizenship. If you lose your denaturalization case in court, you revert to your previous immigration status before you became a citizen. If you had a valid green card before naturalizing, you would theoretically go back to being a lawful permanent resident. But in practice, the same fraud or misrepresentation that led to denaturalization could also be grounds for removal proceedings to take away your green card as well. If you didn't have a valid underlying status, or if your green card was also obtained fraudulently, you could be placed in deportation proceedings immediately and potentially removed from the United States, separated from your family and everything you've built here over the years. Here's what you absolutely need to understand about protecting yourself under these new 2026 rules. And I want you to pay very close attention to this section because it could save your citizenship. First, and most importantly, if you receive any communication from any government agency questioning your citizenship or asking you to come in for an interview about your naturalization or immigration history, do not respond without speaking to an immigration attorney first. Do not go to that interview alone thinking you can explain everything. Do not answer questions without legal representation present. Anything you say can and will be used against you in denaturalization proceedings. Even if you think you have nothing to hide and you just want to cooperate and clear everything up and show them you're a good person, you absolutely need a lawyer. The government has experienced attorneys working on their side whose job is to build a case against you, and you need someone on your side who understands denaturalization law and can protect your rights. Second, gather and organize all of your immigration documents right now, today, before there's any problem or investigation. Find your original naturalization certificate and make several copies, storing them in different safe locations. Locate all of your old passports from your home country and from the United States, including expired ones. Find all your visas, I-94 arrival departure records, green cards, employment authorization documents, travel permits, refugee travel documents, and any other immigration documents you've ever received over the years. Dig out copies of every single immigration application you ever filed, including your original visa applications from the consulate, asylum applications if applicable, green card applications, work permit applications, and your naturalization application with all supporting documents. Find any correspondence you received from USCIS, the State Department, Immigration Court, or any other immigration-related agency. Organize all of this chronologically in folders by year and keep it in a safe, secure place where you can access it quickly if needed. If there's ever a question about your immigration history, having contemporaneous documents from the time can be incredibly valuable in defending yourself. Thank you so much from the bottom of my heart for being part of the U.S. Immigration Insight community and for taking the time to watch this crucial information today. If you found this video helpful and informative, if you now have a better understanding of the denaturalization rules and how to protect your citizenship, please give this video a thumbs up. If you haven't subscribed to U.S. Immigration Insight yet, please click that subscribe button right now and turn on notifications so you never miss critical updates about U.S. immigration law, visa policies, citizenship issues, and everything else that affects you and your family's future in America. Stay informed, stay protected, know your rights, and I'll see you in the next video where we'll continue breaking down the complex world of U.S. immigration in clear, understandable terms.